Hello, my name is Galip Erdem, and this will be the answers for the Laws and Ethics for Forensics Investigation lecture in Durham College. This is the answers for the assignment 3, and this is the first section, section 1. And this will be about reasonable expectations of privacy. The concept of reasonable expectation of privacy is basically search and seizure laws across multiple jurisdictions through its application, terminology, or legal foundations. And this is basically how it is different in the countries like Canada, United States, United Kingdom, or other European Union approaches, how they approach to privacy rights in police searches, with particular attention to the critical distinctions between the search incident and arrest and search conducted where no arrest is imminent. So let's get started with Canada. The Canada has reasonable expectations of privacy. Basically, it has been recognized extensively by the Canadian Charter of Rights and Freedoms, Section 8, which has been established by the Supreme Court on 1996 with the case of R.V. Edwards. The Supreme Court has developed this so the time of search, possession, or control of the property, ownership of the property, historical use of property, ability to regulate access, existence of subjective expectations of privacy, and objective reasonableness of that expectation. The search incident to arrest is basically the law enforcement may conduct warrantless searches to a lawful arrest, but the Canadian law imposes strict limitations. So they need to have a truly incidental to arrest, like temporally or contextually connected, or it must have conducted for a valid objectives like officer safety, preserving evidence, or discovering evidence related to the offense. They should not be abusive in execution and reasonably conducted given the circumstances. And strip searches require additional justifications and must be conducted in a private area by the same gender officers. So the Canadian approach is basically more restrictive than the United States laws, requiring a direct connection between arrest and the search purpose. Searches without imminent arrest is basically requires a prior judicial authorization through a warrant based on a reasonable ground to believe an offense has been committed, and that evidence will be found at the location to be searched. So the Supreme Court is basically particularly protective of privacy rights in non-arrest situations, especially regarding home searches, digital devices, and personal information. A sample case for this is the R.V. Patrick case in 2009. This case established that even abandoned properties may retain charter protections depending on totality of circumstances. So even if it is an abandoned property, it is still in the boundaries of the charter protection. In the United States, similar to the Canadian Charter of Rights of Freedom, Section 8, the United States has the Constitutional Fourth Amendment, which is basically allows United States citizens to have reasonable expectations of privacy based on originates from American jurisprudence, specifically the Supreme Court case Katz v. United States in 1967. So this case is basically marks to two important points: that individuals must have exhibited an actual expectations of privacy, and the expectation must be one that society is prepared to recognize as reasonable privacy. So this is basically what created the Fourth Amendment. The third incident to arrest is basically the permits, warrantless permits of searches of the arrested persons in the area with their immediate control. And they basically, for the officer's safety and prevent evidence destruction. And the sample case related to that is the Kimmel versus the California in 1969, which permits warrantless searches. About third incidents to arrest, this is significantly limited. In vehicle searches, incident to arrest holding police may search a vehicle only if the arrestee is within reaching distance of passenger compartment, or if it's reasonable to believe evidence of the offense of arrest will be found in the vehicle. And that is defined in the case of Arizona versus Gant in 2009. And there is another case related to the cell phones, which is Riley versus the California in 2014, that prohibits warrantless searches of cell phones incident to arrest, recognizing their unique privacy concerns. Searches without imminent arrest is generally require a warrant support by probable cause and particular description of places to be searched and items to be seized. However, the American law recognizes numerous exceptions like consent, exigent circumstances, plain view doctrine, or automobile exceptions, if the probable cause exists, inventory searches, border searches, and administrative searches. This creates a complex landscape where the warrantless searches are actually quite common despite the warrant requirement principle. And there is a case related to that, which is the Carpenter versus the United States in 2017. This recent decision extends the Fourth Amendment protection to historical cell site location information requiring a warrant, even though there was no physical intrusion or traditional property interest. The court recognized that digital technology creates novel privacy concerns requiring updated Fourth Amendment. In the United Kingdom, a reasonable expectation of privacy is a bit fundamentally different. They historically not using the phrase reasonable expectations of privacy in criminal search and seizure law. Instead, the law of enforcement, the police powers are primarily governed by detailed stationary authority under the Police and Criminal Evidence Act, PACE, that's created in 1984, and its codes of practice which provides specific procedures and safeguards. However, privacy rights entered United Kingdom law throughout the Article 8 of European Convention on Human Rights in 1998. So the Article 8 guarantees that the right to respect for private and family life, home and correspondence. This creates a hybrid system where the stationary power must be exercised compatible with convention rights. Despite Brexit, UK still has the Human Rights Act, European Human Rights Act. About third incident to arrest, in Section 32 of PACE authorizes police to search and arrest person without warrant if the officer has reasonable grounds to believe that the person may present a danger to themselves or others, or possesses anything that might be used to escape custody or constitute evidence relating to any offense. The search must be limited in scope to what's necessary for the purposes. Section 18 of the PACE permits searches of premises occupied or controlled by an arrested person, but requires reasonable ground to suspect that evidence of the indictable offense for which they were arrested or a connected or similar offense will be found. Importantly, Section 18 searches generally require inspector level authorization, though searches immediately upon arrest at the premises may proceed without prior authorization if necessary. The searches without imminent arrest generally requires a warrant under Section 8 of PACE issued by Justice of Peace Magistrate based on reasonable grounds for believing that serious arrestable offense, now indictable offense under amendments, has been committed and that relevant evidence is on the premises. The magistrate must be satisfied that certain conditions are met, that the search is necessary. So a critical distinction in the United Kingdom law is the treatment of illegally obtained evidence. Unlike Canada or the United States, UK courts have discretion under Section 78 of PACE to exclude evidence if it's admissible, would have an adverse effect on the fairness of proceedings, but rarely exercise this power. Evidence obtained through unlawful searches is frequently admitted with the unlawfulness addresses through the means such as civil remedies or disciplinary action against officers. So there is a sample case related to that which is called R.V. Chalkley and Jeffries in 1998. The Court of Appeal cases addressed the admissibility of evidence obtained through the unlawful search. The court held that even where police conduct was unlawful, which was entering premises by deception, evidence should still be admissible if it was not obtained unfairly from the defendant. This demonstrates the United Kingdom's more permissive approach compared to Canada or America, exclusionary disciplines prioritizing truth finding over deterring police misconduct. About the European Union, the reasonable expectations of privacy exists. The European Union protects privacy through multiple overlapping legal instruments. The Article 8 of the European Convention on Human Rights, which all the European Union member states must comply with, basically. That's why it's a European Union convention. Guarantees respect for private and family life. Additionally, the Articles 7 and 8 of the Charter of Fundamental Rights of European Union provide parallel protection. Article 7 protects respect for private and family life, while Article 8 significantly addresses personal data protection. While the European Union law doesn't use the identical reasonable expectations of privacy terminology found in Northern America jurisprudence, the substance of protection is similar, requiring a careful balancing of private rights against legitimate law enforcement needs with strong emphasis on proportionally and necessary. The European Union also has General Data Protection Regulation, which is basically GDPR, while primarily focuses on data processing by private entities, establishes strong privacy principles that influence law enforcement data handling under separate law enforcement directive. About search Standards. A crucial distinction in the European Union context is there is no unified criminal procedure law applicable across all countries. Criminal justice, including search and seizure procedures, remain largely within national competence. Each of the European Union member states maintain its own criminal procedure code and investigative rules. This creates significant variation. For example, German law requires judicial warrants for most searches with strict proportionality requirements, while some southern European countries have historically granted broader powers to investigation magistrates. However, all the members of the European Union must comply with the ECHR standards as interpreted by the European Court of Human Rights, requiring that the searches must be in accordance with the law, which means prescribed by accessible, feasible legal provision. They all must pursue legitimate aims, national security, public safety, prevention of crime. Be necessary in democratic society, which is basically meeting a pressing social need. And they all need to be proportionate to the legitimate aims they pursue. So the Court of Justice of European Union also ensures that European Union law respects these fundamental rights when member states implement the European Union laws. Some member states are significantly more restrictive regarding the search incident arrest, while others permit border police powers. So there are some cross-border considerations. Like the European Union has developed mechanism for cross-border evidence collection, including the European Investigation Order under the directive from the 2014 that facilitates the mutual recognition of investigative measures between member states. So the Digital Rights of Ireland Limited versus the Minister of Communication is a decision from the Court of Justice of European Union struck down the data retention directives which had required telecommunication providers to retain metadata for the law enforcement access. The court held that the directives' blanket retention requirements constitute a serious interference with the Article 7 and 8 of the Charter and then even legitimate law enforcement objectives could not justify such broad, insufficiently limited intrusions on privacy. This case established that the European Union law restricts necessity and proportionally even for the inductive investigation access to personal data, setting a higher standard that many national law and influence subsequent privacy protections in digital context. So let's talk about the differences like the doctrine, foundations and terminology. Canada and USA explicitly employ and use the term reasonable expectations of privacy. United Kingdom relies on stationary frameworks like PACE combined with ECHR, Article 8, and European Union uses respect for life with strong proportionality requirements. Exclusionary rules and remedies. Canada has a strong exclusionary rule under Section 24(2) of the Charter. Evidence excluded if admission would bring administration of justice in dispute. In the United States, the constitutional exclusionary rule with numerous exceptions like good faith, independent source, inevitable discovery, or attenuation. In the United Kingdom, discretionary exclusion under Section 78 of PACE. Evidence rarely excluded solely due to unlawful search. In the United States, it is different and changes based on the countries of the European Union. ranging from strict exclusion like Germany to more flexible approaches like France and Italy. The scope of search and incident to arrest. The United States is most permissive. Wingspan doctrine for person and immediate surroundings through the limited Riley for digital devices. Canada is the most restrictive, requires direct connection to valid arrest objectives, strict limitations on strip searches. The United Kingdom has a moderate approach, stationary framework with inspector authorization required for permissive searches. And in European Union, there is no uniform standard and it changes based on the member country itself. And the warrant requirements and judicial oversight is the Canada generally requires prior judicial authorization with high threshold. In the USA, requires a warrant or recognized exception, probable cause standards. In the United Kingdom, requires a magistrate authorization but with different threshold considerations. In the European Union, most member states require judicial or prosecutorial authorization, with like German having particularly stringent requirements. What about the digital privacy protections? The Canada has a strong protection for digital devices and online informations, which is PIPEDA. USA has a still evolving protection, which has the Carpenter represents straightening trends. In United Kingdom, significant surveillance powers under Investigatory Power Act from the 2016, though subjects to the ECHR constraints. In the European Union, strongest protections are particularly post-Digital Rights Island under the GDPR principles. So, while all four jurisdictions recognize and protect privacy rights in the context of police searches, and they differ substantially in their doctrinal foundations, terminology, practical applications, and remedies for violations, Canada tends towards the most protective individual rights approach. The United States balance strong constitutional protects with numerous practical exceptions, and the United Kingdom emphasizes stationary regulation with flexible evidence rules, and the European Union requires high-level proportionality standards while permitting national variation in implementation. Now about part 2, if the employees' privacy expectations differences in Canada, United Kingdom, United States, or the European Union. So the privacy with the employee privacy expectations changes based on the workplace and home settings and across different jurisdictions. Canada, the United Kingdom, and United States, and the European Union through 4 critical lenses: legal framework, historical evolution, ethical considerations, and social norms. The fundamental tension lies between employer interests in productivity, security, and liability management versus the employee dignity, autonomy, and personal freedom, basically. In Canada, workplace privacy is governed by patchwork of federal and provincial legislations. The Personal Information Protection and Electronic Documentations Act, PIPEDA, applies to federal regulated workplaces and sets out principles for collection, use, and disclosure of personal information. Section 8 of the Charter protects against unreasonable search and seizure, but its application to private sector employment is limited as it primarily applies to government actions. Canadian courts have established that the employees have diminished but not eliminated privacy expectations in the workplace. The Supreme Court in R.V. Cole in 2012 34 held that employees retain some reasonable expectations of privacy even when using employer-provided computers, depending on operational realities, workplace policies, and nature of the information. Factors include that employer policies clearly communicated nature of the work relationship, employees' reasonable expectations given workplace practices, and whether personal use is permitted or prohibited. At home, employees enjoy significantly stronger privacy protections. Remote work monitoring must still comply with PIPEDA. Employers cannot conduct surveillance of employees' homes without consent, and any monitoring of work devices must be appropriately, necessary, and disclosed. In an historical perspective, Canadian labor law evolved from British common law traditions, emphasizing master-servant relationship with minimal worker protections. The modern privacy framework emerged in the 1980s to 2000s with provincial privacy legislations and PIPEDA, driven by the technologies changes and Quebec's civil law tradition of stronger privacy rights. This shift from industrial to knowledge work increased concerns about information collection and surveillance. Especially with the COVID-19, remote work intensified in home privacy debates. So the Canadian ethics emphasize balancing interests through proportionality, a principle embedded in both the charter analysis and privacy legislation. The ethical framework recognizes employee dignity and autonomy while acknowledging legitimate employer interests. Privacy commissioners consistently advocate for privacy by design and minimal collection principles. There is strong ethical opposition to covert surveillance without compelling justification, and it emphasizes on transparency and consent where practical. In a social perspective, Canadian society exhibits high privacy expectations influenced by multiculturalism and the Charter's prominence in public disclosure. Surveys consistently show Canadians value workplace privacy highly, though younger workers may have different expectations regarding technology use. Work from home expansion during COVID-19 intensified debates about monitoring, with general social consensus that home surveillance crosses ethical boundaries. Union culture in Canada strengthens the collective bargaining around monitoring and privacy issues. And these are mostly defined in the Office of Privacy Commissioner. As a non-legal document, guidance on privacy in workplace, they are all defined in the Privacy Commissioner of Canada. This guidance document reflects evolving social and ethical norms around employee monitoring in Canada workplaces, particularly addressing remote work scenarios. The United Kingdom Workplace Privacy Law centers on Data Protection Act on 2018 and the United Kingdom GDPR, which impose strict requirements on processing employee personal data. Article 8 of ECHR, right to respect for the private life, applies even in employment context. The Information Commissioner's Office, the ICO, provides extensive guidance on worker monitoring, requiring employers to conduct data protection impact assessment for surveillance technologies. The Employment Practices Code establishes that the monitoring should be necessary, proportionate, and justified. The key test from Barbulescu v. Romania in 2017, a case involving a Romanian employee but establishing European standards, requires employers to notify workers about monitoring, explain its scope and means, demonstrate legitimate aims, and consider less intrusive alternatives. UK courts have found that the covert monitoring is generally unlawful unless the investigating serious misconduct. The historical perspective of the United Kingdom's approach evolved from common law master-servant doctrine with minimal privacy protections to comprehensive data protection under the European Union influence. The Data Protection Act in 1998, implementing the EU Directive 9546 EC, marked a watershed moment. Historically, British workplaces operated under assumption of employer prerogative, but European human rights law fundamentally shifted this balance from the 1990s onwards. Post-Brexit, the UK retained GDPR principles, demonstrating their social acceptance. Ethical perspective of the United Kingdom workplace frameworks emphasizes dignity at work, strongly influenced by European human rights tradition. The Advisory, Conciliation and Arbitration Service, ACAS, promotes ethical employment practices balancing interests. There is ethical consensus that the surveillance should be transparent, proportionate, and respectful of human dignity. The British philosophical tradition of liberal individualism supports workplace privacy as essential to human flourishing and autonomy. Ethical guidance emphasizes trust-based employment relationships over surveillance-based control. Social perspective of British society demonstrates strong privacy values, though with pragmatic acceptance of reasonable workplace monitoring for legitimate purposes. Social attitudes favor transparency over covert surveillance, and there is general agreement that home environments remain private even during the work hours. Media coverage of workplace surveillance is typically critical, framing excessive monitoring and dystopian, or Orwellian, from George Orwell. Trade unions actively advocate for privacy protections, and worker councils in large enterprises negotiate monitoring policies. The COVID-19 remote work shift intensified public disclosure favoring home private boundaries. And privacy protections. Than other developed nations. No comprehensive federal workplace privacy statute exists. The Fourth Amendment protects only against government employer searches, not private sector surveillance. The Electronic Communications Privacy Act of 1986 prohibits interception of communications but contains broad business use and consent exceptions that allow most employer monitoring. State laws vary considerably. Connecticut and Delaware require notice of electronic monitoring. California protects off-duty conduct and provides some privacy protections through its constitution. The National Labor Relations Act protects some privacy interests during union organizing and sector-specific laws like HIPAA, FCRA that provides limited protection. Courts generally find no reasonable expectations of privacy in workplace settings when employers have clear policies and provide notice. The City of Ontario Virginia Quon 2010 case upheld government employer review of text messages on employer-provided devices, emphasizing policy disclosure and legitimate interests. However, some courts recognize limits on highly offensive intrusions under tort law. At home, employees enjoy stronger but still limited protections. Employers generally cannot conduct physical surveillance of homes, but can monitor work devices and communications with notice. State laws like California AB 1651 prohibit requiring employees to install tracking apps on personal devices. The shift to remote work has created legal ambiguity, with few clear precedents on home monitoring boundaries. The historical perspective of American workplace law evolved from employment at will doctrine with minimal regulation of employer-employee relationship. The Progressive Era and New Deal introduced some worker protections, but privacy was not among them. Unlike Europe, the US never developed comprehensive data protection law, reflecting American prioritizing of business freedom and limited government intervention. The 1960s and 70s privacy debates focused mainly on government surveillance, not workplace monitoring. Recent decades have been incremental state-level privacy legislation responding to technological surveillance capabilities, but federal actions remains limited. On an ethical perspective of American workplace, privacy are divided, reflecting broader ideological tension between libertarian business rights and progressive worker protection values. Business and ethics often emphasize employer property rights and legitimate interest in productivity and security. Progressive ethics stress worker dignity, autonomy, and power imbalances necessitating protective regulations. Bioethics and technology ethics increasingly warn about algorithmic management, constant monitoring, and psychological harms. However, American ethical framework generally accept employer monitoring more readily than European approaches, consistent with emphasis on contractual freedom and private property rights. American social attitudes toward workplace privacy are complex and often contradictory. Surveys show Americans value privacy highly in principle but accept workplace monitoring pragmatically, particularly with notice. There is greater acceptance of monitoring in high security contexts or where employers own the equipment. However, social attitudes are shifting, particularly among young workers who object to invasive surveillance like bathroom monitoring, keystroke logging, or AI-powered productivity tracking. The gig economy and remote work intensified debates with growing criticism of bossware and Amazon-style surveillance. Social movements around worker rights increasingly frame privacy as a dignity issue. Media coverage of extreme surveillance, like Amazon warehouse monitoring, Uber drive tracking, generates public backlash, suggesting social norms favor reasonable limits even in the absence of legal requirements. Union campaigns increasingly emphasize data rights and algorithmic fairness, and that can be found in MLAT 2019 Electronic Monitoring Survey. The European Union provides the strongest workplace privacy protection globally through the GDPR. The Charter of Fundamental Rights, Article 7 and 8, and ECHR Article 8, GDPR Article 88 specifically addresses employment data processing, requiring European Union member states to provide specific rules ensuring rights and freedoms regarding employment data processing. GDPR principles mandate that the employee monitoring must meet strict requirements, lawful basis, typically legitimate interest balanced against worker rights, purpose limitation, data minimization, transparency and accountability. The European Court of Human Rights, established in Barbulescu, Vagina, Romania, 2017, that workplace monitoring must meet a four-part test. Was advance notice provided? What was the extent and nature of monitoring? Were legitimate reasons provided? Was less intrusive means possible? The Court of Justice of the European Union has held that workers retain fundamental rights even in employment. Employers must conduct data protection impact assessment for high-risk monitoring, appoint data protection officers, and allow worker representatives to participate in monitoring policy decisions. Covert surveillance is almost never possible under European law. At home, European law provides exceptionally strong protections. GDPR's household exemption and right to private life mean employers cannot monitor home environments, even during work hours, without explicit, freely given consent. Several member states have enacted specific remote work laws limiting employee intrusion into home spaces. In a historical perspective of European Union, privacy law evolved from the post-World War II human rights consciousness, with protection of dignity and personal autonomy as foundational values. The 1950 ECHR established privacy as fundamental right in reaction to totalitarian surveillance states. Germany's experience with Nazi and Stasi surveillance profoundly influenced European privacy law, leading a strong data protection principles. The 1995 Data Protection Directive marked comprehensive privacy regulation, updated by GDPR in 2018, to address digital age challenges. This history reflects European social democracy and emphasizes on balancing economic interests with fundamental rights, constraining sharply with American business freedom approaches. An ethical perspective of European Union framework emphasizes human dignity as paramount and non-negotiable, viewing privacy as essential to human autonomy and democratic society. The principle of data protection by design and by default reflects ethical commitment to proactive rights protection. European ethics view employment relationships through a power imbalance lens, necessitating strong worker protections. The precautionary principles applies to surveillance technologies, potential harms, warrant restrictions, even before definitive evidence of damage. Consultation with work councils and data protection authorities reflects ethical commitment to democratic decision-making and stakeholder participation. European Union ethics strongly reject utilitarian justifications that sacrifice individual dignity for efficiency gain. The right to explanation for algorithmic decisions reflect the ethical values of transparency in human agency. From the social perspective, European Union societies exhibit the highest privacy expectations globally, viewing privacy as fundamental cultural value tied to human dignity. Strong trade unions and works councils actively shape workplace monitoring policies through co-determination rights in many member states. Social acceptance of monitoring is conditional on strict transparency, necessity, and proportionality. Public disclosure of frames excessive surveillance as incompatible with democratic values and worker dignity. The European Union's surveillance export controls reflect societal opposition to technologies enabling oppressive monitoring. European workers express less willingness to accept monitoring than American counterparts, even with the productivity justifications. COVID-19 remote work intensified European debates with strong social consensus that home environments must remain private sanctuaries. Media regularly criticized surveillance capitalism and digital Taylorism. Youth movement increasingly mobilized around the data rights and digital sovereignty. Social norms strongly favor trust-based management over surveillance-based control, viewing monitoring as evidence of management failure rather than legitimate oversight. The European Trade Union Institute (ETUI) in 2021 Algorithmic Management and Collective Bargaining document examines European worker experience with surveillance technologies and documents the social and ethical concerns of driving European regulatory approaches to workplace monitoring, contrasting European and American social attitudes. Based on the jurisdictions, employee expectations of privacy is the strongest in the United Kingdom legally, and afterwards the Canada, and then the UK, and the last is the USA. Based on the employer discretion, the United States has the most employer discretion, which is higher than the United Kingdom and Canada, and the least is the European Union. The home protection is the universally the stronger than workplace, with the European Union providing strongest shields for the home protection. For transparency requirements, again, the European Union mandates extensive disclosure while the USA requires minimal notice. And for the enforcement mechanism, European Union has significant penalties for the companies, where the USA relies mainly on tort litigation. And reasonable workplace privacy expectations vary dramatically across jurisdictions, reflecting different legal traditions, historical experience, ethical frameworks, and social values. The workplace-home distinction remains significant everywhere, with homes receiving stronger protection. However, the degree of protection differs markedly. The European Union provides comprehensive, dignity-centered protection. Canada and the United Kingdom balance interests through the proportional frameworks for both employers and the employee. And the United States offers minimal protections for an employee, while highest for the employer discretion. As remote work blurs workplace home boundaries and surveillance technology advance, these justifications differences become increasingly significant for multinational employers and internationally mobile workers. Understanding these varied perspectives, legal, historical, ethical, and social, is essential for navigating the complex landscape of workplace privacy in an interconnected global economy. Now I will be talking about the part 3 and section A, the computer search warrants in Canada and constitutional requirements and case analysis, such as when the warrants are required, when the Crown lost, and when the Crown won. Part A starts with when a warrant is required for search and seizure of a suspect's computer. In Canada, the constitutional requirements for search warrants flows directly from Section 8 of Canadian Charter of Rights and Freedoms, which guarantees the right to be secure against unreasonable search or seizure. The Supreme Court of Canada has established that the searches conducted without prior authorization are prima facie unreasonable, unless the Crown can demonstrate the search falls within recognized exception. The Hunter v. Southam test, this case is the foundational case in 1984, established the framework for reasonable searches in Canada. Justice Dixon held that Section 8 protects the people, not places, and its purpose is to prevent unjustified searches before they happen, not simply to provide remedies afterwards. This means prior authorization, a warrant, is generally required unless the situation falls within established exceptions. So, application to the computer searches, the Supreme Court has recognized the digital devices contain vast amount of high personal information, warranting heightened privacy protections in RV Wu case in 2013. The court held that the computers are not analogous to physical containers. Their unique nature, the ability to store massive amounts of diverse personal information, requires specific judicial authorization that contemplates the device's digital nature. When the warrant is basically required, the Crown needs a search warrant to search and seize a suspect's computer in the following circumstances. Standard criminal investigation. When the police have reasonable grounds to believe an offense has been committed and evidence will be found on the computer, they must obtain a warrant under Section 487 of the Criminal Code specifying that the computer or the digital device. Second, no recognized exceptions applies. Warrants are required unless one of the narrow exceptions applies. The burden is on the Crown to establish that an exception justifies the warrantless search. Third, the reasonable expectation of privacy exists. Where the suspect has a reasonable expectation of privacy in the computers, this applies to personal computers in homes, laptops and mobile devices, work computers, and where personal use is permitted or expected, shared computers where the suspect has a password protected account, cloud storage, and email accounts. The fourth one is the content versus the metadata distinction. While R.V. Spencer in 2014 established that the subscriber information tied to IP addresses attracts privacy interests, the threshold for content searches like emails, documents, or browsing history is higher and virtually always requires a warrant. The warrantless searches may be permitted, like in the some exceptions are the third incidence to arrest is the R.V. Farron in 2014. Police may search a cell phone incident to lawful arrest, but only if the search is truly incidental. The arrest is lawful. The search is conducted for valid law enforcement purposes like officer safety, preservation of evidence, and discovery of evidence. The search is conducted promptly after arrest. The search is limited in nature and scope. The consent should be valid, informed, and voluntarily consent from someone with authority over the device. However, in the R.V. Cole case, we're going to talk about that, established that the employer consent doesn't necessarily vitiate employee privacy in work computers. Imminent destruction of evidence or immediate danger, the threshold is high, mere convenience doesn't suffice. The plain view doctrine is basically if police lawfully access a device and evidence is immediately apparent without additional searching throughout, it's rare for digital devices given their nature. And of course, the border searches, they are the exceptions. So when required, a search warrant for computer must specify the offense under investigation, identify the place or thing to be searched with sufficient particularity, be based on reasonable grounds established by oath, be issued by neutral judicial officer, contemplate the digital nature of the search, may require forensic imaging to avoid evidence destruction. The Wu revelation is basically fundamentally changed computer search law in Canada. The court held that the warrant for a residence doesn't automatically authorize searching computers found within. The computers require separate specific authorization because they contain vastly more information than physical spaces. They can contain information unrelated to the premises. They may belong to the third parties. They can access information stored remotely. Part B. Cases where Crown lost for failing to obtain warrant. So we will be talking about two cases. The first case will be R.V. Morelli in 2010. This is about Stephen Morelli was suspected of uploading child pornography to the internet. Police obtained Morelli's subscriber information from the ISP without a warrant. They then attended his residence, arrested him, and seized his computer without a warrant. They relied on exigent circumstances, claiming evidence might be destroyed. At the trial, Morelli was convicted, but he appealed the warrantless search. The court of first instance, the trial judge, found the warrantless search valid under exigent circumstances and convicted Morelli. The Saskatchewan Court Appeal upheld the conviction, finding the exigent circumstances exception justified the warrantless search. The Supreme Court of Canada in 2010 anonymously allowed the appeal and entered an acquittal. So the Justice Fish from the Supreme Court, writing for the court, held that no valid exigent circumstances. The police failed to establish genuine exigent circumstances. Their concern about potential evidence destruction was speculative and insufficient. Police had time to obtain a warrant but chose not to. The court emphasized that exigent circumstances require an objectively reasonable basis for believing evidence will be imminently be destroyed. Mere possibility doesn't suffice. Section 8 of Charter violation. The warrantless search of Morelli's home and seizure of his computer violated Section 8. The court noted that computer contained vast amount of highly personal information, warranting strong privacy protection. Section 24.2 exclusion. Under Section 24.2 of the Charter, the court excluded the evidence because admitting it would bring the administration of justice into disrepute. The violation was serious. Police had no warrant and no valid exception. The impact on the accused's charter-protected interest was significant, and the search was not conducted in good faith. Acquitted entered. Because the excluded evidence was essential to the Crown's case, the Supreme Court entered an acquittal rather than ordering a new trial. So, as a summary, the exigent circumstances must be objectively demonstrated, not based on speculation. Police convenience or desire to avoid the warrant process doesn't create exigency. Warrantless computer searches face high scrutiny given privacy interests. Section 24.2 analyzes favored excluding where police had opportunity to obtain a warrant. And the R. Wu 2013 case of electricity theft, marijuana grow operation. The warrant authorized searching the premises but didn't significantly mention computers. During the search, police found and searched 3 computers, discovering evidence of electricity theft. At trial, Wu challenged the computer searches. Court of First Instance, the trial British Columbia Supreme Court. The trial judge held that the residence search warrant implicitly authorized searching computers found within the residence Wu convicted. British Columbia Court of Appeal allowed Wu's appeal and ordered a new trial. The court held that the warrant for the premises didn't automatically authorize searching computers found there. Computers require specific judicial authorization. The Supreme Court of Canada anonymously dismissed the Crown's appeal, upholding the Court of Appeal's decision and confirming the need for a new trial. So based on this, the Justice Cromwell from the Supreme Court, writing the anonymous court, held that the computers are not containers. The court rejects the analogy between computers and physical containers like filing cabinets. Computers can store vastly more information, including information unrelated to the premises and owned by third parties or stored remotely. Separate authorizations are required. A warrant to search premises does not automatically authorize searching computers found within. Computers require specific additional authorization that contemplates their unique digital nature. Warrant particularity. Search warrants must describe with sufficient particularity what is to be searched. Given computer's unique nature, police seeking to search computer must bring this to the authorizing judge's attention and obtain specific authorization. Section 8 violation. The search of the computers exceeded the scope of warrant authorization, violating the Section 8 of the Charter. Section 24.2 exclusion. The court excluded the evidence from the computers. Although the officers acted in good faith, the law was unclear at that time. The Charter violation was significant, and the privacy interests at stake were substantial. The court held that admitting the evidence would bring the administration of justice into disrepute. Because of other admissible evidence remained, the court ordered a new trial rather than entering an acquittal. So as a summary, the computers require separate specific authorization beyond premises warrants. The digital nature of search must be contemplated by an issuing judge. Warrants must specifically authorize computer searches. Even good faith doesn't automatically save evidence from excluding under section 24(2). So if we compare the Morelli case versus the Wu case, let's talk about the similarities. Both involved warrantless computer searches violating section 8. Both resulted in evidence exclusion under section 24(2). Both involved serious criminal charges like child pornography and drug cultivating or electricity theft. Both reached to the Supreme Court of Canada. Both resulted in Crown losses and acquittal in Morelli and new trial in views. Both emphasizes computers' unique privacy implications, and both required proof of proper authorization for computer searches. So there is a critical distinction between these two. The Morelli deals with the complete absence of warrant and the failure to establish a valid exception, which is exigent circumstances. The police had opportunity to obtain a warrant but didn't, acting in bad faith. The violation was serious and the court sent a strong message about respecting privacy rights by entering acquittal. Wu deals with insufficient warrant scope. Police had a premises warrant but it didn't extend to computers. The violation occurred because the law was evolving and police acted in good faith under the existing understanding. However, Wu fundamentally changed Canadian law by establishing that computers are qualitatively different from other containers and require specific authorization. Morelli is about obtaining a warrant at all, and Wu is about obtaining the right kind of warrant. Together they established that warrants are generally required for computer searches and those warrants must specifically contemplate and authorize digital nature of the search. Now part C, where the Crown won without an advance warrant. There are two cases where the government prevailed without a warrant. One of the cases is the R.V. Farron and the other one is the R.V. Giles. Kevin Farron was arrested following an armed robbery at jewelry store. Immediately after his arrest, police searched his cell phone without a warrant and discovered photos of the handgun used in robbery, cash and jewelry, as well as draft text messages that implicated him in the crime. Farron challenged the warrantless search at trial. Court of First Instance, the trial Ontario Superior Court of Justice. The trial judge held that the warrantless cell phone search was valid as a search incident to arrest. The search was conducted promptly after the lawful arrest and was for valid law enforcement purposes. Farron was convicted. The Ontario Court of Appeal, the Court of Appeal upheld the conviction, finding the search incident to arrest doctrine applied to cell phones. Though it should be conducted with proper limitation, the court held that the search was justified and the evidence admissible. The Supreme Court of Canada in 2014 dismissed the appeal in a 4-3 split decision upholding Farron's conviction. That we have talked about this in the lectures before. So let's talk about the legal analysis about this case. The search incident to arrest applies to cell phones. The majority held that the common law power to search incident to arrest extends to cell phones, but with important limitation to protect privacy interests. There is a 4-part test met. The search was valid because the arrest was lawful. The search was truly incidental to the arrest. The search was conducted for valid law enforcement purposes, for discovering of the evidence. The nature and extent were reasonable. Additional requirements for cell phones. The majority of established specific requirements for cell phone search incidents to arrest: that the arrest must be lawful, the search must be truly incidental to arrest, the nature and extent must be reasonable, police must take detailed notes about what was searched and why, the search must be limited in scope, police should generally conduct the search at the scene of arrest. Section 8 also justified: while cell phones containing significant private information, the search was reasonable given the lawful arrest and adherence to the search incident to the arrest principle. And there was no Section 24(2) exclusion. The search didn't violate the charter, so exclusion wasn't warranted. So the dissent would have required a warrant for cell phone searches, arguing that it was done by the judges like Lebel and Moldaver. The cell phones contain vastly more personal information than items traditionally searchable incident to the arrest. The search incident to arrest power should not extend to devices containing such comprehensive personal data. Police had time to obtain a warrant, but Feoren was in custody already. The unique nature of cell phones warrants different treatment. So, why did the Crown won this case? Despite the dissent's concerns, the majority held that the search incident to arrest doctrine applied, creating a recognized exception to the warrant requirement. The key factors were: the arrest was lawful and based on reasonable grounds, the search was immediate and directly connected to the arrest, the search had valid law enforcement purposes, the scope was limited to what was reasonably necessary, the search was conducted properly under the circumstances. Subsequent appeal was the final decision. No further appeal were possible. So the Crown won this R.V. Feoren case. The second case is about R.V. Gillis in 2007. Stephen Gillis was arrested at border crossing attempting to enter Canada from the United States. Customs officers found child pornography on his laptop computer during a routine border examination. Giles challenged that the warrantless search, arguing it violated Section 8 of the Charter. So the Court of First Instance, the trial happened in the Ontario Superior Court of Justice. The trial judge found that the border search was lawful under the Customs Act and didn't require a warrant. The routine border examination authority permitted the search. Giles was convicted of possessing child pornography. Ontario Court of Appeal in 2007 that appeal dismissed Giles' appeal and upheld the conviction. So the legal basis on this is basically the border search exception. The court held that the border searches fall within a well-established exception to the warrant requirement. The state's sovereignty right to control who and what enters the country justifies reduced privacy expectations at borders. Customs Act Authority Section 99 grants custom officers authority to examine goods being brought into Canada, including examining computers and electronic devices as well. Reduced expectations of privacy at borders. While computers generally attract high privacy protection, travelers at borders have reduced privacy expectations. People crossing borders know that they are subject to examination and must accept the reduced privacy. Reasonable search under Section 8. The court held the border search was reasonable under Section 8. Border searches serve important state interests, border integrity, preventing illegal imports, reduced privacy expectations and borders. Search was not arbitrary, conducted as a part of routine border examination. Scope was reasonable. Officer had authority to examine electronic devices. And the balanced approach, the court acknowledged that the computers containing significant private information, but held that the border control needs outweigh privacy interest in this context, provided searches aren't arbitrary or abusive. And Since the search was reasonable under Section 8, there was no charter violation and no need for Section 24(2) analysis. So the Supreme Court of Canada, Giles sought to leave the appeal to the Supreme Court, but leave was denied. The Court of Appeal decision stands as the final authority. So why the Crown won this case? The Crown prevailed because the border search exception is a well-recognized exception to warrant requirements, reduced privacy expectations at international borders, stationary authority under Customs Act, important state interests in border control, search was of routine examination, not arbitrary, officers acted within the lawful authority. So if we compare the Farron and the Giles cases, both involved warrantless searches of digital devices, both resulted in Crown victories and convictions upheld, both relied on recognized exceptions to warrant requirements, both reached appellate courts, both involved serious crime offenses, both courts acknowledged computers, phones had privacy implications, and both emphasized balancing privacy within law enforcement needs. There's a critical distinction. The Farron involves the search incident to arrest exception in a domestic criminal investigation. So this is a narrow, well-established exception requiring immediate connection to lawful arrest and valid law enforcement purposes. Giles' involvement was about border search exception, reflecting that the sovereignty of authority to control borders. So this exception rests on reduced privacy expectations when entering Canada or basically in any other country, and statutory authority under the Customs Act. So let's talk about why the Crown lost, and let's distinguish this Part B cases where the Crown lost and Part C where the Crown won. The cases where the Crown won. So the Crown lost in Morelli and Wu, but won in Farron and Giles. First, valid exceptions versus no valid exceptions. In Morelli case claimed that exigent circumstances but failed to prove them objectively. In Wu case claimed that implicit premises warrant but insufficient for computers. In Farron case, there was a valid search incident to lawful arrest, and in Giles case, valid border search exception. The police opportunity to obtain a warrant. In Morelli case, the police had time to get warrant but did not. In the Wu case, police could have specified computers in warrant. In Farron case, immediate post-arrest search, no practical opportunity. In Giles' case, the border searches don't require warrants at all. The good faith. Morelli case, the bad faith, police simply bypassed warrant process. In Wu case, there was a good faith, but law changed after the search. And in Farron case, the good faith application of search incident to arrest. In Giles' case, the good faith application of border search authority. The types of exceptions. Morelli case attempted to use exigent circumstances, but no established at that time. In Wu case, attempted to use implicit authorization, but it was being rejected. In Farron case, search incident to arrest recognized but with limitations. In Giles' case, it was a border search, so it was quite well established. Stationary versus the common law. In the Morelli case, no statutory or common law exception applied. In Wu case, relied on common law interpretations, but it's been rejected. In Farron case, common law search incident to arrest is accepted. In Giles' case, statutory authority, the Custom Act, plus the common law border exception exists. So in the critical differences in these cases where the Crown lost, police either had no warrant or insufficient warrant authorization, no valid recognized exception applied, police had no opportunity to obtain proper authorization, but had police had opportunity to obtain proper authorization but didn't. The violation was serious enough to warrant exclusion under Section 24(2). The cases where the Crown won, the Farron and Giles cases, uh, a well-recognized exception to the warrant requirement applied. Police acted within lawful authority in common law or statutory. The searches were reasonable under Section 8 given the circumstances. Privacy expectations, while significant, were outweighed by law enforcement's need in specific contexts. So for the law enforcement's warrants are required unless a clear exceptions applied. Search incidents to arrest works, but only with strict limitations. Border searches have reduced warrant requirements. Convenience doesn't justify warrantless searches. Speculative concerns about evidence destruction aren't enough. Premises warrants don't automatically cover computers, and implicit authorization doesn't satisfy the charter requirements. Now this is the part 4 of the assignment, where I will be talking about the Saudi Arabia's legal system that is different significantly from what we are used to in Canada, specifically how Saudi courts handle illegally obtained evidences. My subject is about Saudi Arabia since my student number ends with 5. So let's get started with the fundamental question. Is the evidence obtained through illegal search and seizure admissible in Saudi courts? The answer is yes, and this it might be surprising because unlike Canada and United States or the United Kingdom, Saudi Arabia does not apply strict exclusionary rule. Courts generally admit evidence even when it's been obtained illegally. However, this doesn't mean anything goes. Investigators who violate procedures can face personal accountability and disciplinary action, but the evidence itself is typically remains admissible in the court. So this approach is rooted in the Islamic legal principles that prioritize discovering the truth over enforcing procedural technicalities. Let's talk about two primary laws that governs this area. First, Law of Criminal Procedure from 2001. Article 2 states that proceedings contrary to Sharia are invalid, but this focuses on procedural validity, not automatic evidence suppression. Article 60, however, is particularly important. It requires investigators to keep seized materials confidential, and if they unlawfully disclose information, they will be held accountable. Here is no provision to exclude the evidence itself. The second law is the Law of Evidence from 2021. This is a major reform law. The Article 3 states that evidence that is established is equivalent to that which is directly observed. This really emphasizes truth discovery over procedural purity. Article 97 says evidence must be relevant, material, and admissible, but again, there is no explicit. So, why does the Saudi Arabia take this approach? There are 3 interconnected reasons. First one is the Islamic legal philosophy. The concept of haqq or truth seeking is paramount in Islamic jurisprudence. The Hanbali school of Islamic law, which is Saudi Arabia follows, emphasizes discovering objective truth over procedural technicalities. The thinking is, if evidence is reliable and probative, why should it be excluded just because of what it was collected? That would potentially let guilty people go free based on technicality. The second is the historical practice. For over 1,000 years, Islamic courts have focused primarily on witnesses' testimony and confessions. The Western concept of excluding solid evidence due to collection methods is actually foreign to traditional Sharia practice. There is no historical precedent for it. The third one is the judicial discretion and accountability. Rather than excluding evidence, Saudi law takes a different approach. It holds investigators personally accountable for violations. Judges also have broad discretion in weighing differences' credibility. This separates the investigator's misconduct from the evidence's probative value. As the law of criminal procedure states, a court shall base its judgment on the evidence submitted during the trial. The historical evolution of the evidence law starts from the 7th century and the 10th century CE. Classical Sharia was developed. The focus was on three types of evidence: witness testimony or shahada, confession or ikrar, and oath or yamin. No concepts of exclusionary rules. From 1932 to 2000, after the kingdom was established, judges applied uncodified Sharia, relying heavily on the medieval Hanbali texts. There were minimal written procedural rules, and judges had enormous discretion. From 2001 to the present day, we see modern codifications. The criminal procedure law in 2001 and the evidence law in 2021 were major steps. These reforms maintained the traditional philosophy. They added investigator accountability, but they didn't adopt Western-style evidence exclusion. Compare this to Western development. The United States developed the exclusionary rule through the Fourth Amendment, and cases like Weeks versus the US or in 1914 or the Map versus v. Ohio in 1961. Canada adopted Section 24(2) of the Charter in 1982. The Saudi Arabia never went down this path because it's rooted in a completely different legal traditions. Are there any exceptions? First, judicial discretion. Judges may give less weight to evidence obtained through the serious procedural violations. Article 2 of the Criminal Procedure Law does allow invalidation of proceedings, contrary to Sharia. But this is entirely up to the judge's discretion. It is not automatic. Second, torture obtained confessions. The law prohibits torture, and the evidence law requires confessions to be made freely. However, international human rights organizations report that enforcement here is inconsistent, which is a serious concern. The third, foreign obtained evidence. The evidence law says courts can consider evidence from outside Saudi Arabia as long as it doesn't violate public order. So there is some scrutiny, but foreign evidence is typically admitted if it's relevant. The fourth one is the privacy violation. The criminal procedure law does protect privacy of persons and dwellings. Violations led to investigators' accountability. But again, the evidence actually remains admissible unless a judge exercises discretion. The key insight here is that these are not automatic exclusions like we have in Canada. There are areas where judges may question evidence credibility, but there is no guarantee that they actually will. So, practical implications for digital forensics. So what does this mean in real investigations in digital forensics? For digital evidence, you seize a smartphone without a proper warrant in procedures. In Saudi Arabia, that evidence will likely still be admitted. The 2021 evidence law specifically recognizes digital evidence with the same authority as written proof. The court's concern is authenticity. Is this really data from the defendant's phone? Not how you got it. For search and seizures, items found during unlawful searches are typically admissible. The investigator might face disciplinary actions, but the evidence can be used. There is no fruit of poisonous tree doctrine like in American law. For witnesses' testimony, even testimony obtained through intimidation may be questioned by the judge but is rarely excluded. Islamic evidentiary standards focus more on number of witnesses. You need 2 to 4 witnesses depending on the crime, rather than one collection procedures. The best practice, though, evidence is admissible. Investigators should still follow proper procedures. Because to avoid personal accountability, to maintain evidence credibility with the judge, and to align with the Saudi Vision 2030 reforms that emphasize transparency and international standards. So let's talk about 4 key takeaways. 1. There is no exclusionary rule in Saudi Arabia. Illegally obtained evidences is not automatically excluded. 2. This is based on Islamic legal foundations where the truth seeking supersedes the procedural technicalities. 3. 2 key laws governs this area: the law of criminal procedure from 2001 and the law of evidence from 2021. Both emphasize investigator accountability rather than evidence exclusion. And the 4, there are limited exceptions where judges have discretion to discount evidence, but these are rare and entirely case specific. This represents a fundamentally different approach to evidence law than what we practice in the Western jurisdiction. And these are my references. Now I will be talking about exigent circumstances in Canadian law, and let's get started. Let's get started with what are exigent circumstances. Let's think of them as emergency exceptions. Normally, police need a warrant, but when there is an emergency, someone's life may be in danger, evidence is about to be destroyed, or a suspect is about to escape. Waiting for a warrant defeats the whole purpose. Section 8 of the Charter usually requires warrants, but courts get that sometimes you just can't wait. The case I will be talking about will be the R.V. Peterson 2017. So what happened is actually the police responded to a 911 call and victim was already at the hospital. Officers smelled marijuana at Peterson's apartment. He admitted having roaches and agreed to no case seizure, no charges. Police entered without warrant, claiming he might destroy the evidence. Once inside, they saw guns, drugs, cash, bulletproof vest in the plain view. Why the police were wrong? No real urgency, because the Peterson agreed to hand over roaches, no motive to destroy them. Convenience, not emergency. Officer admitted getting warrant not worth all that procedure. They created their own safety concerns by choosing to enter. Destroying roaches with no charges didn't meet exigent threshold. So the ruling was evidence excluded, convictions set aside. So the lesson from this case is basically exigent circumstances means urgency, not convenience. You can't create your own emergency and then use it as justification. The emergency must exist before you decide to enter. Homes have the highest privacy protection under Section 8. So in the key case, the Supreme Court laid out 3-part test. You need reasonable ground and an offense happened, reasonable grounds that evidence is there, and reasonable belief that immediate action is necessary. All 3 parts must be met. This isn't something you use every day, only in real emergencies. Here is why the digital forensics is special. Digital evidence has unique challenges, like volatile data, RAM. It can gone seconds when you power off your computer or your laptop. Suspects can remotely wipe devices from anywhere. Devices auto-lock and encrypt themselves. Cloud services can delete data on schedules. All of this creates time pressures that traditional investigations just don't face. Here's another real world scenario. A child exploitation cases where there is active abuse happening, cyber attacks with ongoing breaches, terrorism cases with imminent threats, drug trafficking where evidence will be wiped remotely. The common thread: if you wait for warrant, the evidence will be gone. The best practices for investigators: document everything. Only seize what's absolutely necessary. Try to get a warrant after if you can. Keep your chain of custody tight. Follow proper forensics protocols. What are the risks? If you fail to do them, your evidence gets excluded and you face charter violations, civil liability, professional misconduct charges, and the whole case could be toasted. The key is documentation. Explain why it was an emergency, what you did, and why waiting was not an option. To wrap up, this is an emergency exception, not a routine. Digital evidence is genuinely fragile and time sensitive. You must meet all three parts of Peterson test, no shortcuts. Your documentation is critical and always balance urgency with charter rights. Yes, speed matters, but so does doing it right. And these are my references. This is part 6. I will be talking about handling privileged information in digital forensics. So let's consider this case. An investigator executes a legitimate search warrant on a computer looking for evidence of fraud. During the search, they find a folder labeled legal correspondence or emails from a law firm. This presents an immediate legal challenge because solicitor-client privilege is one of the most protected rights in Canadian law. The investigator must handle the situation carefully because improper handling could invalidate the entire search. So, what is privileged information? It refers to protected communication between certain parties. The most important for investigators is solicitor-client privilege, which covers communication between a lawyer and their client for the purpose of legal advice. Other types include medical privilege and spousal privilege. The key legal principle is that even a valid search warrant does not automatically override privilege. This protection is fundamental to Canadian justice system. So, what is the Canadian legal standard for this? The leading case is Lavelle, Reckel and Heinz v. Canada Attorney General in 2002. In this case, the RCMP searched a law office and seized potentially privileged documents. The Supreme Court of Canada ruled that the search was conducted improperly. The court used strong language stating that privilege must be jealously guarded and established a clear protocol that investigators must follow when they encounter privileged materials during searches. So the step-by-step protocol will be first, stop immediately upon recognizing potentially privileged information. Do not continue reading or attempt to determine if it's actually privileged. Second, seal the material by creating a protected folder, encrypting it, or imagining it separating to prevent further access. Third, segregate these materials completely from other evidence while maintaining proper chain of custody. The fourth, notify the privilege holder, usually the client or their lawyer, to give them an opportunity to assert privilege. The fifth one will be the seeking court review by applying to a judge for determining of whether the material is actually privileged and whether any exception applies. This protocol is legally required in Canada, not merely a best practice. So, several practical considerations are important. Detailed documentation is essential. Investigators should record when they encountered the material, what they saw before stopping, and every subsequent action taken. Timing matters because unreasonable delay in addressing privilege claims can itself create legal problems. Modern forensic tools should be used to isolate and protect potentially privileged materials without contaminating them. Investigators should consult with their organization's legal counsel or the Crown Counsel immediately rather than waiting until court proceedings. The corporate investigations, company lawyers can provide guidance, while criminal investigations require early involvement of Crown Counsel. The key takeaways are privilege is a fundamental right in Canadian legal system, not a technicality. Investigators are not the arbiters of privilege. Their role is to recognize it, stop, and preserve it for judicial determination. Following the proper protocol actually protects the investigation because ignoring privilege can result in the entire search being invalidated and potential civil liability. The guiding principle should be, when in doubt about whether the material is privileged, seal it and seek court guidance. The Lavelle case demonstrates that Canadian courts take privilege violations seriously. And this is my reference. This is part 7. I will be examining the impacts of the United States Cloud Act on Canada's Mutual Legal Assistance Treaty Framework. The Cloud Act represents a significant shift in how cross-border data requests are handled, with implications for investigators, privacy rights, due process, and law enforcement effectiveness. What is the Cloud Act? The Cloud Act, or Clarifying Lawful Overseas Use of Data Act, was enacted in the United States in 2018. This legislation authorizes U.S. law enforcement agencies to compel American technology companies to produce electronic data regardless of where that data is physically stored around the world. This represents a fundamental departure from traditional international cooperation frameworks. The Act applies to major U.S. service providers including Microsoft, Google, Apple, Amazon, and Facebook. Under the Cloud Act, U.S. authorities can issue warrants or subpoenas directly to these companies, requiring them to hand over data even if it's stored on servers in Canada or other foreign countries. This ability to bypass geographic boundaries has significant implications for international data sovereignty and privacy protections. Canada's Mutual Legal Assistance Treaty system has been the traditional mechanism for cross-border criminal investigations since 1985. Under this framework, when Canadian investigators need data stored in the United States, they submit a formal request through the Canadian Department of Justice to their United States counterparts. This is a government-to-government process that includes judicial oversight and formal documentation requirements. The United States authorities then execute the request domestically and return the results through official channels. While this system provides strong due process protections, it has significant drawbacks in terms of speed. MLAT requests typically take 6 to 12 months to complete, and complex cases can take even longer. In the context of modern digital investigations, where the evidence can be deleted in seconds, this timeline is often impractical. Where Cloud Act meets MLAT. The Cloud Act creates a significant collision with Canada's MLAT framework by establishing two parallel pathways for accessing the same data. Path 1 is the Cloud Act route, where the US law enforcement can issue warrants directly to American companies and receive data within days or even hours. Path 2 is the traditional MLAT route, which takes months and involves formal diplomatic channels. The critical issue is that the United States authorities can now bypass MLAT entirely, when dealing with data stored by American companies, even if that data belongs to the Canadian citizens or it's stored on the Canadian soil. This creates a fundamental asymmetry because Canadian investigators must still use the slower MLAT process when requesting data from United States, while US investigators can use faster Cloud Act process to access data held by American companies operating in Canada. This disparity has significant implications for sovereignty and balances of investigative capabilities. The impact on the investigators. The Cloud Act creates several challenges. The Canadian investigators, first, they must continue using the slower MLAT process when requesting data from US companies, while American investigators can access data about Canadians much more quickly through direct company compliance. This creates an investigative disadvantage in the time-sensitive cases such as terrorism, child exploitations, or fraud, where digital evidence is critical. Second, investigators must now be more strategic about evidence preservation, often needing to act quickly to prevent data deletion before formal requests can be processed. Third, investigators need to determine where data is physically stored and which legal regime applies, adding complexity to investigation planning. However, there are some benefits. When the US authorities initiate cooperation through the Cloud Act, Canadian investigators may receive information faster than through traditional channels. Additionally, Canada can potentially negotiate executive agreements under the Cloud Act framework that would allow Canadian authorities to make direct requests to the US companies, though no such agreement currently exists. The Cloud Act raises serious privacy concerns for Canadians. When the United States authorities use the Cloud Act to access data about the Canadians, this occurs without any Canadian court oversight or judicial authorization. The process bypasses Canadian privacy legislation, including the Personal Information Protection and Electronic Documentation Act, or PIPEDA, which normally governs how private sector organizations handle personal information. US legal standards for data access are generally considered less stringent than Canadian standards, meaning data that would be protected in Canada may be accessible under US law. Furthermore, companies complying with the Cloud Act requires typically prohibited from notifying the affected individuals, meaning Canadians may never know their data was accessed by foreign law enforcement. This creates potential conflicts with Section 8 of the Canadian Charter of Rights and Freedoms, which protects against unreasonable search and seizure. Provincial privacy legislation such as Quebec's Law 25 may also be implicated. The fundamental concern is that Canadians lose the privacy protections they would normally enjoy under the Canadian law simply because their data happens to be stored in American company. The Cloud Act significantly affects due process protection that Canadians normally expect. The traditional due process includes judicial authorization through Canadian courts, the ability to challenge warrants, and consistent applications of evidentiary standards. Under the Cloud Act, US authorities obtain warrants from US courts applying US legal standards with no Canadian judicial involvement. Canadians have limited practical ability to challenge these warrants since they occur within the US legal system, and they may not even be aware that their data has been accessed until it's used in proceedings. The evidentiary standards that US courts apply may differ from Canadian standards, potentially allowing access to data that would require a higher threshold of proof in Canada. There is also reduced transparency because Cloud Act processes occur largely outside public view and without formal documentation that accompanies MLAT requests. These concerns raise fundamental questions about sovereignty and extraterritorial jurisdiction. Essentially, US law is being applied to data about Canadian citizens and residents, sometimes stored on Canadian territory, without Canadian legal process. This represents a significant extension of US jurisdiction into Canadian affairs and raises concern about whether Canadian legal sovereignty is being adequately protected. The Cloud Act has mixed effects on law enforcement effectiveness. On the positive side, the ability to access data within days rather than months represents a substantial improvement in investigating time-sensitive crimes. This is particularly valuable for cases involving terrorism, child exploitation, kidnapping, or ongoing fraud, where delays can mean lost evidence or continued victimization. The Cloud Act also enables better international cooperation by reducing bureaucratic barriers and allowing for more fluid information sharing between allied law enforcement agencies. For joint investigations between US and Canadian authorities, the Cloud Act can significantly improve operational efficiency. However, there are negative impacts as well. The existing of inconsistent legal frameworks between the traditional MLAT system and the Cloud Act creates a confusion about which process to use and when. Evidence obtained through the Cloud Act without following Canadian legal procedures may face admissibility challenges in the Canadian courts, particularly in criminal proceedings where charter protections apply. Defense lawyers can argue that evidence was obtained in violation of Canadian privacy rights or without proper judicial authorization. Additionally, the perception that investigations bypass Canadian sovereignty can undermine public trust in law enforcement and potentially harm international relations. Several potential solutions exist to address the tension between the Cloud Act and Canadian interests. The most significant would be negotiating a Canada-US executive agreement under the Cloud Act framework. Such an agreement would allow Canadian authorities to make direct requests to the US companies without going through the MLAT process, creating a reciprocal access to eliminating the current asymmetry. However, the Cloud Act requires that countries entering such agreements demonstrate robust privacy protections and adherence to rule of law principles. Canada would need to ensure that any agreement includes appropriate safeguards for Canadian privacy rights and judicial oversight. Legislative responses at the Canadian level could include data localization requirements that mandate certain types of sensitive data be stored within Canada, though this approach has economic costs and may not be practical for all data types. Canada could also strengthen privacy protections through amendments to PIPEDA or other legislations that specifically addresses cross-border data access. Finally, clear guidance for investigators is needed to navigate the complex landscape of MLAT versus Cloud Act processes, including protocols for determining which approach to use and how to ensure evidence will be admissible in Canadian courts. The key takeaways from this is the first, the Cloud Act fundamentally disrupts the traditional MLAT framework that has governed cross-border criminal investigations for decades. Second, while it creates faster access to evidence, this speed comes at the cost of reduced privacy. The reduced privacy protections and judicial oversight. The third, the Cloud Act raises significant concerns about Canadian privacy rights and legal sovereignty, as Canadian data becomes subject to US legal processes without Canadian involvement. The fourth, investigators face both new challenges in terms of legal complexity and new opportunities for faster international cooperation. Fifth, Canada needs a strategic response that could include negotiating an executive agreement, implementing new legislation, or requiring data localization for sensitive information. Ultimately, this issue requires balancing three critical interests: the security needs of effective law enforcement, the privacy rights of Canadian citizens, and Canadian legal sovereignty. Finding the right balance will require ongoing dialogue between Canadian and the US authorities, input from privacy advocates and civil society, and potentially new legislative frameworks that protect Canadian interests while enabling effective international cooperation in combating serious crime. And these are my references. This is part 8. I will be exploring 3 important privacy principles that exist in other parts of the world but are not part of Canada's PIPEDA framework. So, as a quick refresher, the PIPEDA has 10 fair information principles. These cover everything from consent to data access. They have served Canada well since 2000, but the world has moved on. These were designed before social media, cloud computing, and AI. And we can list them as accountability, identifying purposes, consent, limiting collections, limiting use, disclosure and retention, accuracy, safeguards, openness, individual access, and challenging compliance. So the first principle is data portability. Think about you switching cell phone providers. You lose all your history. Data portability from GDPR Article 20 says that's not okay. Your data is yours. You should be able to move it around. The Rogers to Bell example hits home in Toronto. Imagine exporting everything in a format Bell could import. No starting from scratch. The benefits will be shifting powers to consumers, promotes market competition. The problems? Technical complexity, such as what format will the data be moved. The security risks when moving large data packages, burden on small businesses, and philosophical confusions about inferred data. If Netflix predicts you will like a movie, is that your data or theirs? The second principle, right to erasure, the right to be forgotten. From a Spanish case where someone wanted Google to stop showing old financial troubles, Article 17 says under certain circumstances you can demand data deletion. The shoplifting example, should one teenage mistake follow you forever online? Right to erasure says no. The benefits will be the rehabilitation, protecting from abuse like revenge, porn, or doxing, privacy restorations. The problems starts with colliding with the freedom of speech, press freedom, or historical records. Who decides public interest? Technical reality, data doesn't disappear through backups, copies, blockchain. Jurisdictional chaos, the European Union says erase, the United States says that's censorship. Whose law will we follow? The third principle is the privacy by design and default from GDPR Article 25. Most forward-thinking of the three. Build privacy in from day one, don't add it at the end. By default means safest setting is automatic. Remember Facebook making posts public without asking? That's backwards. Default should be private. Instagram example resonates. How many times have settings changed unexpectedly? The benefits of the privacy by design is preventing violations before they happen, creates better products, cultural shift, and accountability. The problems starts with vague standards like what's appropriate, could slow innovations like startups move fast, assessment burden, time and money, subjective interpretations. Privacy means different things to different people. So why does Canada have these? PIPEDA enacted in 2000. No smartphones, no social media or cloud computing. Based on 1980s OECD principles for paper records. Canada's approach was business friendly. GDPR came in 2018, designed for modern digital reality. Canada's catching up with Bill C-27, but we are years behind. This explains why different jurisdictions take different approaches. The bottom line, why this matters? Cross-border cases need multiple frameworks. Evidence may have erasure requests pending. You might assess if companies followed privacy by design. Key takeaway will be the privacy law evolves faster than legislation. Understanding global principles prepares you for modern investigations. And these are my references. This is part 9. I will be presenting an analysis of PHIPA Decision 101, a case that demonstrates the intersection of privacy law, access rights, and solicitor-client privilege in healthcare environments. This decision from Ontario's Information and Privacy Commissioner involves University Health Network and presents practical challenges that arise in investigations, balancing competing privacy interests, determining what information can be disclosed, and understanding how privilege protections operate in real-world scenarios. So let's talk about the case first. The facts are straightforward. A patient at University Health Network became the subject of allegations from another patient regarding inappropriate conduct. Following a meeting with the hospital staff about these allegations, the complainant submitted an access request under both PHIPA and PHIPA. The request was comprehensive: identification of the complaint, documentation of allegations, copies of all communications, and staff notes. The hospital located responsive records but denied access, citing multiple exemptions under both statutes. Dissatisfied with the hospital's response, the complainant escalated to the Information and Privacy Commissioner. This led to the formal education being examined today, which addresses fundamental questions about access rights when multiple parties have privacy claims over the same records. The complainant's request was methodical: 10 specific components recovering all aspects of the incident. He requested identifying information, temporal details, copies of handwritten notes, verbatim statements, and all written communications, including emails and text messages. Through the mediation process, the hospital identified a 5-page email chain between staff members. The critical detail here is that these weren't routine administrative communications documenting an incident. These were communications between hospital staff and legal counsel seeking guidance on how to proceed with the matter. The distinction between factual documentation and legal consultation becomes the pivotal issue in determining whether disclosure is required. It's a distinction that needs to be recognized in investigative work when dealing with institutional records. Understanding the applicable legal frameworks is essential before analyzing the decision. There are 2 statutes at here. PIPA, the Personal Health Information Protection Act, governs access to personal health information held by health information custodians. Section 52 establishes individual access rights with specific exemptions. PHIPA, Freedom of Information and Protection of Privacy Act, provides broader access rights to information held by public institutions. Section 47.1 addresses access to one's own personal information. University Health Network operates under both regimes. It's a health information custodian under PIPA and a public institution under PHIPA. The educator must determine which statute governs which portion of the record based on whether it contains personal health information as defined in PIPA Section 4. Section 8.1 and Section 8.4 of PIPA governs how these statutes interact essentially. PIPA takes priority for personal health information with residual PHIPA rights for other information in the records. The educator made two preliminary determinations that shaped the entire analysis. First determination: the record contains personal health information of both the complainant and the other patient. Medical record numbers, treatment informations, and clinic visit details all satisfy the section 4.41 definition. Second determination was the record is not dedicated primarily to the complainant's personal health information under section 52.3. This is significant. If a record is dedicated primarily to one person's PHI, that person gets access to the entire record. If not, access is limited to the portion that can reasonably be severed. The educator examined the record's purpose. These emails weren't created to document the complainant's medical care. They were created to determine the hospital's response to an allegation. Both patients' information appears throughout for contextual purposes. The practical implication is the complainant's access rights under PIPA extends only to his reasonably severable personal health information, not the entire record. This is a common scenario in investigations where information about multiple individuals is intermingled in institutional records. Now the hospital's core defense is solicitor-client privilege. The hospital's position was clear. These emails constitute communications between staff and legal counsel for the purpose of obtaining legal advice on managing a sensitive patient relations issue. Under Section 9 of PHIPA, which flows through the PIPA via Section 52(1)(f), such communications are privileged. The educators reviewed the record and concurred. The emails clearly show staff seeking or receiving legal advice, making them subject to solicitor-client communication privilege. The crucial point about the privilege is a class-based exemption. Unlike the content-based exceptions that be applied to specific portions, privilege attaches to the entire communication. It's a binary. Either the entire communication is privileged or it is not. There is no ability to excise the legal advice and release the factual background. Therefore, despite the theoretical severability of some personal health information, the application of privilege to the record as a whole precludes any disclosure. The hospital's denial stands. The complainant argued privilege waiver based on alleged disclosure at a social event. The adjudicator rejected this. Casual discussion of a matter doesn't constitute waiver of privilege over subsequent formal. Legal constitutions. The consistent with established privilege doctrine. While upholding the privilege claim, the adjudicator found the hospital's search efforts inadequate. This is an important finding from an investigative perspective. The complainant challenged the reasonableness of the search, asserting that additional records must exist. The adjudicator agreed. When questioned about search methodology, which personnel conducted searches, which system and locations were searched, what methods were employed, whether the records were destroyed per retention schedules, the hospital provided insufficient detail. The adjudicator ordered an additional search with a detailed affidavit requirement. The affidavit must identify searches by name and position, describe locations and systems searched, explain methodology, report results, and address retention and destruction policies. This reinforces a principle relevant to forensic investigations. Institutions must document search efforts comprehensively. Assertions of compliance aren't sufficient. Evidence demonstrating reasonable effort is required. This applies equally in forensic investigations when conducting searches or challenging institutional responses. This case illustrates how fundamental privacy principles operate in practice. Collection limitation. The hospital collected complaints information strictly for addressing a patient's safety concerns. The collection was bounded and purposeful, not exploratory. Purposifications and use limitation. The information was collected for one defined purpose: investigating and responding to allegations. This satisfies the requirement that organizations specify collection purposes and limit subsequent use. Individual participation. PIPA embodies the principle that individuals should access their own health information. However, this case demonstrates that this principle has boundaries. It must be balanced against other legitimate interests, other individuals' privacy rights, and privilege protections. Accountability. The hospital bears responsibility for protecting both patients' privacy. It can't favor one party's interests without legal justification. From an investigative standpoint, this case shows how privacy principles that appear straightforward in theory create practical tensions in multi-party situations. These same tensions arise in forensics work when handling records involving multiple individuals. From an evidentiary perspective, this case reinforces important principles about search standards and admissibility. The reasonable search standard doesn't require absolute certainty that no additional record exists. However, it requires demonstration of reasonable efforts by knowledgeable personnel using appropriate methods in proper locations. With adequate documentation, the hospital failed this standard. There is also an evidentiary rule worth noting. The complainant attempted to introduce documentation from a college of social workers proceeding to support his waiver argument. The adjudicator excluded this evidence under Section 56 of the Social Work and Social Service Work Act, which renders such records inadmissible in other proceedings. This illustrates a principle relevant to forensic investigations. Relevance doesn't equal admissibility. Documents must satisfy both relevance and admissibility requirements. Understanding this evidentiary rule is essential when collecting and presenting evidence. The adjudicator also noted that the responsive emails were maintained in legal files. Proper custody for privileged documents. This chain of custody observation supports the characterization of these as genuine legal consultations rather than ordinary admissive records. For an information security perspective, directly relevant to digital forensics, this case has practical implications. Access controls. The hospital maintains multiple systems: email for general communication, electronic medical records for patient information, and legal file repositories for privileged communications. Effective role-based access controls are essential to ensure only authorized personnel can access sensitive or privileged information. In forensics investigations, understanding these access control structures is necessary when collecting evidence. Audit capabilities and retention. The adjudicator's search order demonstrates why robust audit systems matter. Systems must track where records are stored, document access and modifications, and maintain retention schedules. Without these capabilities, institutions can't adequately respond to access requests or search orders, and effective forensic examinations become difficult. Data classification. This case involves three information levels requiring different protections. Legally privileged communications, the highest protection. Personal health information under PIPA and personal information under PHIPA. Systems must be configured to classify and protect each category appropriately. Effective information security isn't just technical implementation. It is fundamental to fulfilling legal obligations and supporting investigative requirements. Turning to critical analysis, starting with what the adjudicator handled well. First, the methodical approach. The adjudicator worked systematically through both statutes, applied established legal principles, and recognized that two patients have competing privacy interests. There is no automatic deference to the institution, which is appropriate. Second, the dedicated primary analysis was sound. The adjudicator correctly focused on the recourse purpose rather than simply counting mentions of each party. This properly applies the test from PIPA Decision 17. Third, ordering an additional search was justified. The hospital's initial evidence regarding search effort was clearly inadequate, and the adjudicator appropriately held them accountable. The legal analysis is competent and follows established precedent. However, from a practical and investigative perspective, there are concerns about whether this decision strikes the right balance between competing interests. There are three main concerns with this decision. First, the blanket privilege application. Privilege as a class-based exemption in established law, that's understood, but in practice the record contains both legal advice and factual information. Could these be separated? The adjudicator doesn't meaningfully engage with this question. The principle that privilege is indivisible may be legally established, but whether that produces optimal outcomes in every case is debatable. Second is insufficient balancing. The adjudicator noted that the complainant was informed verbally about the allegations, but there is inadequate analysis of whether verbal disclosure equals access to written records. In investigative work, there is significant difference between oral summaries and documentary evidence. Can someone effectively verify accuracy, identify inconsistencies, or prepare responses based solely on verbal information? This isn't adequately addressed. The third is the procedural fairness receives insufficient consideration. When someone faces allegations affecting their relationship with an institution, their care, or their reputation, neutral justice principles suggest they should know the case against them. This isn't formal discipline, understood. Nevertheless, there are consequences. The decision emphasizes privacy and privilege, which are both important, but procedural fairness gets minimal analysis. From an investigative perspective, this gap is concerning. In forensic work, procedural fairness is fundamental when individuals face allegations or adverse findings. Alternative approaches. Several alternative approaches might have produced better outcomes. First, enhanced in-camera review. The adjudicator could have conducted line-by-line analysis to determine whether any portions, even discrete factual statements, could be severed from legal advice. Perhaps the conclusion would remain unchanged, but the analysis would be more thorough. Second, non-privileged summary production. The hospital could have been directed to prepare a summary containing only factual information, dates, parties, allegation, nature, stripped of legal analysis or strategy. Factual information isn't inherently privileged, it's merely contained in a privileged communication. Whether it can be extracted and disclosed separately is a question the decision doesn't explore. Third alternative is dispute resolution. Facilitated discussion might have identified mutually acceptable solution. Perhaps limited disclosure, reduction, or other approaches could address the complainant's legitimate concerns while protecting the other patient's privacy and the hospital's privilege. These alternatives deserve consideration, and the decision doesn't explain why they weren't pursued or wouldn't work. The legal references, number one will be the first legal reference will be the R.V. McClure, the Supreme Court of Canada's 2001 decision establishing the framework for solicitor-client privilege. The court characterized privilege as a principle of fundamental justice and a civil right that is nearly absolute. The court recognized narrow exceptions, notably the innocence at stake exception, where an accused's liberty is threatened and privileged information is necessary to establish innocence. However, these exceptions are rare and carefully limited. The adjudicator applied McClure correctly. She recognized that privilege serves important systematic functions, facilitates candid lawyer-client communication, and shouldn't be set aside absent compelling circumstances. However, McClure arose in a criminal context involving potential imprisonment. The innocent at stake exception makes sense when charter rights and liberty are at stake. This case arises in an administrative health information context. No one's liberty is threatened. The question, which the Supreme Court hasn't definitively addressed, is whether privilege should be equally absolute in this different context, or whether a more nuanced approach might be appropriate. This isn't criticism of adjudicator who was bound by McClure. Rather, it's a question about whether the legal framework itself is optimally suited to administrative context. From an investigative perspective, this matters. Frameworks needs to balance all relevant interests appropriately. The second reference is Blank v. Canada, the Supreme Court's 2006 decision distinguishing two types of privileges. Litigation privilege protects documents prepared for the dominant purpose of existing contemplated litigation. This privilege is temporary. It ends when litigation concludes. Solicitor-client communication privilege protects confidential communications between lawyer and client for giving or receiving legal advice. This privilege is permanent, surviving the matter's conclusion, the relationship's termination, and even the client's death. The adjudicator correctly identified solicitor-client communication privilege, not litigation privilege. No litigation was contemplated. Staff were seeking advice on managing a patient complaint. Under Blank, the privilege continues indefinitely. The adjudicator applied the law correctly. However, there is this question. Should communications seeking risk management advice receive identical protections as communications in contemplating of litigations? The hospital was essentially asking how to minimize institutional liability. This is risk management or institutional strategy. It may differ from traditional legal advice. Blank establishes the doctrinal framework but doesn't address whether all in-house counsel communications warrant permanent absolute privilege. From practical investigative standpoint, this matters. If risk management communications receive the same protections as litigation advice, it significantly limits what information can be accessed when investigating institutional conduct. The decision has practical implications for healthcare institutions and for those conducting investigations. For health institutions, document search procedures meticulously. Assertions are insufficient, evidence of methodology, locations, and results is required. Maintain clear retention schedules, clearly identify privileged communication and maintain them in separate, secure system. Recognize the need to balance multiple interests, transparency, privilege, and multiple parties' privacy rights. For investigators and patients, access rights are significant but not limited. Solicitor-client privilege can preclude access to one's own information. Other parties' privacy rights can limit disclosure. However, recourse mechanisms exist. Complaints to the IPC, challenges to the search adequacy, requirements for evidentiary justification. From an investigative perspective, understanding these limits is crucial. When conducting an investigation involving institutional records, anticipating privilege claims, understanding what constitutes reasonable searches, and knowing when to challenge inadequate institutional responses is necessary. The system provides checks and balances, though outcomes aren't guaranteed. As investigators, working within this framework while advocating for appropriate disclosure when legitimate investigative needs exist is essential. It's important to acknowledge the genuine difficulty when multiple parties assert legitimate but conflicting interests. The complainant has substantial interests. Knowing allegations affecting him, ability to respond effectively, protection of reputation and institutional relationships. These are legitimate concerns grounded in fairness principles. The other patient has substantial interests. Safety concerns, confidentiality expectations when reporting, privacy in health information, these are equally legitimate. The hospital positioned between these competing claims. They must investigate safety concerns, obtaining legal advice on sensitive matters, protect both patients' privacy, and maintain appropriate documentation while safeguarding privileged communications. There is no outcome satisfying all parties. Someone's interest will be limited. From an investigative perspective, the question is whether the law strikes an appropriate balance or whether the legitimate investigative and fairness interests are being subordinated to institutional privilege claims. This tension mirrors what arises in forensic investigations, balancing multiple legitimate interests when they conflict. The overall assessment is that this decision is legally sound but practically problematic. The adjudicator correctly applied current law. Solicitor-client privilege attaches to these communications under existing doctrine. Search requirements were appropriate. Both patients' privacy interests were considered. However, the decision is overly rigid. The absolute nature of privilege forecloses nuanced approach that might allow partial factual disclosure. Procedural fairness concern, the complainant's ability to meaningfully respond to allegations, deserve more substantial analysis than they received. Alternative approaches to balancing these interests deserved exploration. This is competent legal analysis adhering to established principles. However, adherence to technical legal requirements doesn't always produce optimal outcomes from a practical or justice perspective. From an investigative standpoint, this decision illustrates a broader challenge. When institutional privilege claims are applied broadly, the ability to access information for legitimate investigative purposes becomes significantly constrained. Whether that balance is appropriate in an ongoing question in access and privacy law. So, assessment and the result will be this is a strong legal performance but significant room for practical improvement. So my recommendations that several reforms could improve the outcomes in similar cases. First, development of clearer guidelines regarding privilege severability. Can factual background information be meaningfully distinguished from legal advice and strategy? If so, principles should be articulated for making such distinctions. If not, that conclusion should be explained more rigorously than current jurisprudence provides. Second, consideration of mandatory mediation or alternative dispute resolution for cases involving allegations between patients. Before proceeding to formal education, parties should be required to explore whether the creative solutions might address everyone's concerns. Third, standardizations of search requirements. The institutions should be provided with template affidavits and clear guidelines regarding expected search procedures. Technology-assisted review protocols might also be developed. Fourth, enhanced transparency through publications of decisions with detailed reasoning and creation of guidance documents. This promotes understanding of rights and obligations among institutions and individuals. These reforms wouldn't undermine privilege or compromise privacy. Rather, they would enhance fairness and efficiency within the existing legal framework. 5 key takeaways from this analysis would be, starting with solicitor-client privilege is a powerful doctrine. It is nearly absolute and can preclude access even to no one's own information. This is by design, but it produces real consequences for individuals seeking information. Second, privacy operates at multiple levels. Personal health information, personal information, and privileged information each receive protection, but through different statutory schemes with different standards. Third, access rights are significant but not absolute. Even when seeking one's own information, legitimate exemptions may apply. Fourth, documentation of searches is essential. Institutions can't simply assert compliance. They must provide detailed evidence of reasonable search efforts. Fifth, will be balancing competing interests in inherently difficult. When multiple parties assert conflicting rights, perfect solutions are rare. The question is whether the law minimizes conflict while maximizing the fairness. The fundamental point is that the law operates at the intersection of rights, responsibilities, and human interests. Tensions are inevitable and resolution is often imperfect.